Well, look, thanks everybody for joining us for this 25th Triple ID conversation. Just explain, we will be recording this, but it won't be recording your names within the recording. And we'll have a presentation of, I think, 20 to 25 minutes, and then we'll move to a question and answer, and we'll stop exactly on the hour. And if you have questions, either just raise your hand at the end or put them in chat so you won't forget them later. So let me introduce our speaker today, Michael Doherty. Michael is Professor of Legal Design at Lancaster University, possibly the first Professor of Legal Design, is that right? Anywhere or
Yes,
in the UK? Yeah,
in the world, yeah,
that's
that's
established
excellent, yeah.
in the field. And he's founding editor of the Legal Design Journal, which he's going to talk about today. And he's been a leading figure in legal information design, applying design thinking to legal problems, processes, and his research explores cultural barriers to integrating design into law, which is really interesting to me, and implications of information design for how law works, for the rule of law. So, Michael, looking forward to this. Do you want to share your screen now?
I will certainly try. And how's that looking? Great.
Yep.
Okay, super. Okay. Well, thanks very much. Thanks, Rob, and to all at Triple ID for the invitation to speak to you this afternoon. I know that Rob is the founder of a journal, the Information Design Journal, and other people in the call have been involved in running that journal. So it'll be interesting to compare notes in the Q&A. And Rob has also taken a strong interest in the legal application of information design and has worked with one of my own key inspirations in the field of legal design, Helena Hapio. There we go. I realized with the audience that I should probably just take a short period of time to explain what legal design is, because it's a field with which not many people are familiar, including many lawyers. Essentially, it's the application of design tools, methods, and mindsets to law. And this really puzzles lots of lawyers who think, well, what on earth can design have to do with law? But as we know, design thinking can be applied to, to documents and other sorts of information artifacts, to systems and processes, to institutions, and to the experiences of people. So legal design is just all those things. It manifests in all those different ways. The application of design to documents, legal documents, contracts, information design, the experience of people within legal systems, etc. It is a really new field. The first use of the term legal design was probably in the 1990s with a Swiss researcher called Colette Brunschwig. But really, as a field of practice, we're not much more than a decade old. 2012, 2013 was probably when some of the foundational things happened. They include when Margaret Hagan founded the Legal Design Lab at Stanford. Margaret, this is an example of Margaret's work on the screen here. This is a page from her open access book. She has this unique and very visually engaging style. She's worked on great projects. She's trained lots and lots of people who've now sort of gone back to their homes around the world to practice legal design. She created this open access book, Law by Design, which was for a lot of us the first extended piece of work that we read in the field. And of course, it's helped that she's had kind of Stanford's weight and reputation behind her. At the same time, 2013, the New Law Lab was founded at Northeastern University in Boston under the directorship of Dan Jackson. And again, that's done lots of work in relation to projects and also education over the last 12 years in the Massachusetts area. And in Europe, I'll talk about how legal design has developed in Europe on the next slide. But essentially, those initial pioneers came together in about 2013 and created some events. And really from there, it's been a process of building capacity and extending the reach of legal design as a discipline and as a field of practice. So we have been quite evangelical about it, but we've reached the stage now where there are about 40 to 50 programs around the world where students can learn about legal design at varying levels. Our key event really is the Legal Design Summit, and the last Legal Design Summit in Helsinki in 2023, there were 500 participants at that event from 50 countries from around the world, and tickets sold out within, well, they were free, but tickets all went within about 48 hours. So I think they could have had double the number of registrations. But despite that, we still think of ourselves as a very nascent field of practice. So where did it come from? Say different, there are probably two different kind of seed beds from which the roots of legal design have grown. And in Europe, the key pioneers really have been Helena Hapio, who's a Finnish commercial lawyer, and Stefania Passera, who's an Italian graphic designer, but based in Helsinki, and they started working together in the late noughties. And this is a very, very broad brush, but the key theme of European legal design, or the roots of European legal design, have really been around information and communication and documents. So many of the main players have worked with commercial clients, on contracts, terms and conditions, and privacy notices. Another examples would be the Hammurabi Legal Design Agency in Paris, which is one of the leading agencies, which has worked with very prestigious clients and is now focusing on the issue of dark patterns in online interactions. And Astrid Kohlmeier, based in Munich, who's worked with global companies like global pharmaceutical companies, global professional service companies. I'll give an example of her work on the next slide. But the starting point has been really this. This is a slide, a quote that Helena uses in almost every presentation I've seen her give. And it shows that for lawyers, the turn towards the toolkit of design comes from dissatisfaction. It comes from dissatisfaction with the communication practices of lawyers. That contracts are unreadable. They're unreadable to the people who commission those contracts, the business people who rely on those contracts. Terms and conditions must be the biggest lie on the internet, that box we all tick that says, I have read and understood the terms and conditions. Every organization, every website has a privacy policy that never changes how people approach the protection of their own privacy. So that's where some of that desire to change things comes from. And there's just an example of her work, but I particularly wanted to focus on this one. It's an example from Airbus. They worked. The initial impetus came from an in-house lawyer, Ines Curtius, and they worked with design agencies, including Astrid Kohlmeier in Munich, Lieke Bielen from Amsterdam. And it was the particular issue that Airbus worked with lots of innovation startups. Lots of bright young kids coming out of university, setting up startup companies, creating technical innovations, and then wanting to sell them to Airbus. So of course Airbus had a non-disclosure agreement to structure the relationship through the negotiation phase, and it looked very much like this. This is just a kind of a sample of the pages from that agreement, and they realized the people they were negotiating with just signed these things and had no idea what they meant. They had no way of interpreting their obligations under the non-disclosure agreement. And so they simply applied some of the methodologies of, in particular, of document design and information design, and we can see how they ended up here. So it's not very clear from the pictures, but they use process diagrams, timelines, more considered use of white space, headings, simple things like headings, simple things like use of a limited color palette, icons, infographics, etc. And it significantly increased the readability score of that document. And crucially, it also found that it increased the level of trust in between the partners to the negotiation. So there was a range of benefits that came from it. In relation to the US, the story is a little bit different. So most of the the focus, most of the initial activity on legal design in the US has come out of innovation labs in universities. So I mentioned Stanford Legal Design Lab, New Law Lab. There are now a range of other innovation or legal design labs at other US law schools. And their focus has been very much on what in the States they call poverty law, or access to justice. The concern has been around citizens' understandings of their legal rights, their experiences of being self-represented in court, and of engaging with law enforcement. So just some simple examples here. So just some user guides. This first one in relation to what happens when you receive an eviction letter, what happens if you're called to appear before a traffic court, and using this sort of visual language to provide people with clearer advice and guidance as to how to navigate those sorts of experiences. Again, it's very, very small here, but one of the things they point out is you can't just solve this by coming up with a leaflet and giving it to people. So the leaflet is only one part of the strategy to provide support. And another particular example is this was a project of the Graphic Advocacy Project, which was a New York-based nonprofit run by my friend Hallie J. Pope. And as you can see, it's about voting rights in Texas, and whether people who have a limited amount of documentation can actually go and exercise their right to vote. And it uses this cartoon style visual approach to explain what people's legal rights under voting law are in that jurisdiction. And this sort of cartoon style has been used in other sorts of legal documents. So Robert DeRoy is a South African-based lawyer, legal designer, who's used this cartoon style to create employment contracts. So the entire contract is in the form of a cartoon. It's very useful for people with low literacy who work in fields like fruit picking in South Africa. So that gives you an absolute whistle-stop tour as to what legal design is. So maybe at the end I'll share the screen in relation to the Legal Design Journal, and we can have a look through it together, and I can show you various things. But this is just a screenshot to give you some idea of the style and an introduction to the ethos of the Legal Design Journal, which I officially launched at that Legal Design Summit in September 2023, and we published our first issue in kind of September, October last year. We're producing our second issue. We're just going to do one issue this year, and we're on track to publish that in the autumn of this year. So again, that just gives you a bit of an oversight of some of the key features of the journal. So we're open access, we use peer review, we're the first and only journal entirely dedicated to legal design in the world. But I think there are some kind of more interesting questions. So firstly, why a journal? In a world that's full of journals, why create yet another journal? Which is a good question. So here's my answer. So one of the first things I did in the field of legal design was at a workshop in Groningen in 2018 that was entitled Legal Design as an Academic Discipline. And I just took a step back and thought, what does that mean? What does it mean for legal design to be an academic discipline? So I looked into that and I wrote something about it, and as well as there being the sorts of things that you would expect. So a discipline has a commonality of methods and approaches. It has, in some respects, a common way of seeing the world and interrogating the world. It has common subjects of interest, but it also has an infrastructure, kind of an internal architecture to enable it to self-sustain. So in 2019, I posed this question in a short article I posted on Medium. Is it time for a legal design journal? and I received positive feedback from the community on that. But essentially, the answer is this, that in the absence of a specialist publication on legal design, then every time that people within the field write about their work in a scholarly way, or even in a practical way as a showcase of their work, it's scattered far and wide. There isn't any single place where that work can be in dialogue with each other. And there's a second issue, which is that a bit like today for this presentation, where I did a kind of a whistle-stop tour of legal design, every time anyone published a piece on legal design that was in either a generalist journal or a specialist journal in a different or related field, they would have to spend a significant chunk of that article explaining what legal design was and justifying its existence and outlining its features. So in a 8,000 word article, we'd all have to spend 3,000 words at the start of every single article explaining again what legal design is. And it also means that, to be a discipline, any self-respecting discipline needs its own journal, or certainly its own places to publish, because otherwise the work that you publish is not really in critical dialogue with each other. The work will always have to be at in some respects, kind of entry-level work. And so for those and other reasons, I thought it was important for the developing infrastructure of legal design as an academic discipline, as a field of practice, to have that kind of platform. And just a final couple of comments, but before we move on, I mentioned the term evangelical at the start, and to some extent, when for those of us who are legal designers writing for more generalist audiences, inevitably it becomes an evangelical piece of work. We want people to understand it and engage with it and believe that it's a real thing and that it can add value to the world. And so we're always in a bit of a cheerleader mode. Whereas if we have a platform where we're speaking to each other, I think it allows us to be far more self-critical and to really interrogate what we're doing and whether we're doing it right and whether it really adds value. And finally, a comment on this: it's nice for people who are in the field to be able to publish for a journal specifically in legal design and have their work evaluated by people who are experts in the field, etc. Okay, so for all sorts of reasons, it was important that we developed a publication platform of some sort, a journal in the field of legal design. And I've used a mixture of pronouns there. So sometimes I've used the word I and sometimes we. But the first thing I did when I decided that we wanted to do something about this as an idea, to turn the idea into something real and concrete, was that we had to approach it as a design challenge. And that meant that it had to involve a process of co-creation. So I'd already had a reasonably successful and very enjoyable academic career for decades. I was at least sort of 2/3 of the way through my academic career before I'd even heard the word design. But design really changed the way in which I saw the world and saw my work and did things in relation to my work. And up until then, almost everything I'd done had been a single project. I've been sole authored. And since 2018, the vast majority of things that I've done have been joint projects and joint author works. So the first thing I did when I realized that this had to be a team effort and co-creation, I sat down and made a list of who I thought were the 25 best legal designers in the entire world. And I vaguely knew some of them, but some of them I didn't know at all. But then I wrote to all of them and called them. And of the 25, and 21 got back to me and said yes. So this became the development team, and this is just a part of it. I've got 2 more slides of lovely faces to share with you. So we worked as a development team. Everyone gave their work, their time and their expertise completely for free. They came from a range of different backgrounds. So some of them are academics, like Katri, who's a teaching fellow at Harvard, and Joaquin now works in Austria, but got his PhD in Germany. Dan's the director of New Law Lab, and some of them are practitioners. So Astrid runs her own consultancy. Marco runs the leading legal design consultancy in Italy, etc., etc. They came from 4 continents and a very, very sort of diverse range of backgrounds. So it includes these people are, I'm sure, kind of strangers to most of you, but these are really kind of most of the leading stars in the field of legal design. So we worked together, and we worked together this way. We almost kind of consciously followed the Stanford model of design thinking, the first stage of which is empathy. So we did user research. We wanted to understand the needs of potential users, both as potential readers and potential writers for us. So in the first instance, we circulated a survey as widely as possible via our networks. We had almost 150 responses from over 30 countries, including from some Asian and some African countries. So that was a bit of a gap in our team, our development team. It remains as a bit of a gap in our editorial team, but we were able to get input from parts of the world and perspectives that were not reflected in our development team. The biggest group by far were private practice lawyers, but we also got responses from in-house lawyers, from public interest, from public officials, from academics, from students, and from designers. And we asked them where they got their information from in relation to legal design at the moment, and what they liked about those information sources, and what frustrated them, and what they would want to see from a journal covering issues of legal design, and even helped us choose our name. And we backed it up with a small number of semi-structured interviews where we took a deeper dive with a smaller group of people. But again, that included voices from the Global South, and that really informed the rest of the process. As a working group, we met periodically, but it was really, really difficult because there was 20 of us. We were in time zones that went from Eastern Australia to the Midwest United States. So one of the challenges we really had was establishing our practices as a working group. And we tried various collaboration tools like Teams, but people didn't like Teams and had trouble logging on. We tried Slack, which even fewer people liked. So that was actually one of the challenges, how to share information and collaborate properly. But despite that, we, on the basis of the user research, developed the journal structure and our publishing policies and our overall goals and ethos. And we had subgroups working on issues like how to get on the main academic indices and our visual style and so forth. I think that we did have a process of innovation. We had a real desire not to be bound by existing approaches to legal academic publishing. So we really questioned lots of things in relation to working with publishers, on publication fees, on the way that peer review works, how it's experienced by people who write for journals, on the role of editorial boards, on the dominance of text in legal writing, and on the hard division between practice and academia that exists in lots of different fields of practice. And we prototyped, we sketched out our policies, we created wireframes of what the websites might look like, etc. I'm very, very sure that no legal journal has ever been created in that particular way. It'd be interesting to see whether journals in other fields, including design, have been created in similar ways. So what did we end up with through that process? We think that we ended up with a journal that reflects our values as people who want to bring design into law and legal practice. So it's completely online. there was a very strong message from our research that people had very little interest in it being a paper publication. If it had been a paper publication, realistically, we would have had to have worked with a publisher, which meant they would have had to have signed up with one of the larger publishing houses and been subject to all the support that they could give, but then all the constraints that would flow from working with an existing publisher. So essentially, we were self-published. So we are, say, we're completely online. We're open from the moment of publication. So some supposedly open access journals actually only make a sample of material available, and then there's and then they keep things behind a paywall for 6, 9, or 12 months. Everything we publish is freely accessible under Creative Commons license from the point of publication. It's diamond opened access. I was really surprised. This is kind of how naive I think I've been in this field, that I didn't realize that a lot of open access journals actually charge people to publish with them. So they so they make people write for them, and then they give them lots of work to do in relation to getting up to scratch, and then they charge them varying sums of money. So one of the supposedly open access journals that was shown to us charged people a $3,000 publication fee. So that was just unacceptable to us, and we went, we cannot go down that particular route. So it's completely free to access and read, and it's also completely free to publish, which does have some cost implications for us. So we have had to find some money to make this thing, to build this thing and to make it available. Other sorts of values, we wanted to break down that artificial divide between what we see as an artificial divide between academia and practice. In any case, it wouldn't make sense for us. An awful lot of the leading practitioners in legal design, some of the names that I've mentioned already, also work as teachers and scholars in universities. Almost all of the leading academics and scholars in universities don't do the type of research that involves simply sitting in their office, reading about what the people do, and then analysing it, critiquing it, and writing it up. Almost all of at least part of the work of legal design academics involves getting out into the community and doing things and designing things and working with people. In other words, practice. So any distinction wouldn't really have made a difference. We wanted to bridge the law and design worlds. I think there's more work to do on that particular objective, generally within our field, but also as a journal. But it meant that we were open to publishing a far more diverse range of objects, visualizations, of case studies, interactive resources than a traditional law journal would have been. And we also wanted to encourage quite a diversity of work, including in multiple languages from around the world. And our user research told us that people wanted this to be a high quality journal. They wanted us to really exercise editorial control to make sure that what we published was the most innovative and the most impactful work. So we have a range of different review policies for different parts of the journal. So this is essentially the structure we came up with. We have an article section, a studio section, and we've tried to have a new section, although that's not really worked. The article section is for scholarly publishing. We look for journals of for articles of between 5,000 and 10,000 words. We had a real debate about peer review. So double-blind peer review is the gold standard, of course, within the academic field, but it can be a really awful experience for people who write and submit their work for journals. So we did go for double-blind peer review on quality grounds, but we're consciously trying to make it a better experience for people. We also looked at publishing platforms. So we went and are currently with Scholastica, which is one of the two main kind of template-based platforms for open access publishing in the academic world. We had a demo with the team from Scholastica. And I was being all enthusiastic about it. And some of the members of the development team said, well, how many different fonts can we use? And their answer was two, a serif and a sans serif font. So at that point, some members of the team wanted to finish the meeting then and said, this will not work for us. We want to show the world how design can be applied to law. And this is the constraints of this particular platform won't allow us to do that. But it's plugged in to the rest of the academic publishing landscape. So it enables us more quickly to get listed on kind of Google Scholar, to get listed on the major academic indices. So essentially we've got a two-facing approach. One is for our academic scholarly work. We've published it on this particular platform, and we've linked it very, very closely. And this is just an example of some of the articles we published in our first issue, with a WordPress-based front page to the journal, which is far more visually engaging, and allows to, and that's where our studio is. Our studio is essentially a place for case studies, for practical work. So a partly gallery, partly for kind of shorter pieces of work, artifacts, visualizations, etc. And that's just an example of some of the things that we published in the first issue there. I've just got about a minute more to go. So that's what we did. That's why we did it. That's how we did it. How did it go? So I'll be very, really honest with you. There were some real challenges. I'm really proud of what we published in our first issue. I think we had good articles. We had good case studies. The way in which the journal looked, the way in which the two parts worked together, eventually sort of came off, and we had really good feedback in relation to it. We had real challenges around our processes and decision making. And this was a real learning curve for us. So essentially we wanted to have lots of people involved, and we didn't want it to be too hierarchical. We didn't want the editor-in-chief to be an absolute tyrant. So we left quite a lot of autonomy for the different editorial collectives to work out how they wanted to work together. And in hindsight, that was maybe a bit of a mistake. In hindsight, I think perhaps we needed a bit more clarity around expectations, and we needed much clearer workflows and processes for receiving submissions, for handling them, and for publishing. So we got there, but it was a little bit of a struggle. A key issue has been generating more submissions. So legal designers, as a people in the field of practice, are really good at doing. They're not great at pausing to write that up in a scholarly format. So we've really had to push and encourage lots of people to do that. And just finally, we're moving platforms. So Scholastica costs about $1,500 a year for the basic publishing platform. We had support in the first year from a grant from the New Law Lab in Boston. We had some financial support from my law school. We crowdfunded a pot of money, but we went, it's not sustainable unless we go out and get some fairly sort of major external sponsorship. In the meantime, my university, Lancaster, did an institutional subscription to Open Journal Systems, which is the alternative to Scholastica, and we're going to publish the second issue and all future issues of the academic articles on the Open Journal Systems. And we're just designing it at how that page is going to look at the moment. So there we go. That's about half an hour, slightly over half an hour, but there we go.
Michael, thank you very much indeed. That's great. Thank you. And are there any no questions in chat? Yeah, I'm extremely jealous of how it's gone for you, because I did start a journal, but that was in the mid-70s, and we didn't have the internet to contact people. and our problem was exactly the same as you, getting submissions. And if you approach publishers, traditional publishers wanted to know that we could guarantee 4 issues a year going on forever. And we decided that no, actually, we'll just publish when we've got enough good stuff.
Yeah. Yeah.
And so that meant that, some years we had 2 issues and some we had 4.
Yeah.
But it was completely confusing to libraries who were subscribing. We used to get checks arriving every year in January
Mm.
for 4 issues. We'd only done 2 of the last year. So we kept having to try and send money back, and it
Yeah. Yeah.
mayhem. So I love your open access thing as well, where you don't need the publisher. I think it's brilliant.
Yeah. Thank you. It's been, the I've worried about really almost every aspect of this particular process. I'm really proud of what we've done, but it certainly has been, it's been one of the more stressful projects that I've undertaken in my professional life. And one aspect of that was just thinking, like, are people going to send us? Are people going to send us their stuff? And to some extent, with the first issue, I was reasonably confident because we had about sort of 10 years worth of people working in this particular field that they didn't have anywhere to publish. So I thought, once they know that there is this place they can publish, then we will get enough submissions. But the original plan was to do 2 issues per year, but we realised that this year we weren't up to speed in relation to building our infrastructure and our processes, so we're going for 1 issue. One big thing I'm doing is at the Legal Design Summit, which is happening again. It's in Helsinki in September this year. We're running a writing workshop. So hopefully we'll have 30 or 40 people in the room for 4 hours where we can talk to them about good practice in relation to writing. And it's going to be a really kind of hands-on interactive thing. Our goal is that at the end of that workshop, there'll be 40 people who have a considered initial plan for writing a piece of work in the field of legal design. And even if only a quarter of them come to us, then essentially we've got our issue for 2026 sorted.
Do you think there's pressure on the academics to publish in prestigious places? When research quality is measured, they rank journals, don't they? And new journals have effectively started at the bottom, I would imagine.
Absolutely, yeah. The extent of formal ranking of journals differs from discipline to discipline. So in business and management studies, there's a very, very clearly understood hierarchy. So it's a table. They go, well, this is number 5 and this is number 6, and you're better publishing in number 5. In law, it's far more fluid than that. The key research assessment exercise in the UK, as you know, is the Research Excellence Framework, the REF, and the guidance from the assessment panel for law REF is they don't look at the journal in which it's published. They evaluate each piece of works that is submitted by each law school on an independent basis. But it's still the case that the place of publication has an influence on the reach and reputation of the article. And certainly I've had conversations with people who've been involved in the journal. Shall I say this? Yeah, amongst friends, so we'll say it. And I said, would your research director in your law school allow you to publish in this journal? And they said no. Because so it's a struggle. But one point I made when we were doing the research on this, because we looked at various rankings of law journals, and everyone has different rankings. But I said, look at this. Out of the top 100, 35 of them were created in the last 15 years. So basically, we just need to do it. We just need to do it and carry on doing it, and we will get listed in the academic indices. Our work will get cited more and more. We will have a greater H index and all those sorts of things. But until we actually do it, none of that will happen. But yeah, it's a struggle.
Anyone else got a question? I've got plenty, but I don't want to dominate.
I think Gillian had a question. Yeah.
I do. Thanks for the presentation.
I think it's really interesting, and I love the fact that the journal is open access because I often run into this problem when I'm looking at journals to submit my work to. I'm wondering, of all of the work that you have seen, like in the first issue published, what do you think the biggest design, um, I don't know, like improvement or advancement, or the greatest benefit, uh, like in a designed piece, have you seen for the average person? I'm just thinking about myself. I redid my will recently,
Mm.
and that was a real hassle, and also something that was like totally foreign and, super hard to understand, needed a lawyer to translate all the information. And like, is that the sort of thing that designers can really add benefit to?
Yes,
Because I
you'd be
understand
unsurprised to
processes.
hear his
Okay.
answer. Um, to some extent, the different sections of the journal are demonstrating different manifestations of legal design. So, the article section, it is very much evaluated um, on the, on academic grounds. On is this original? Is it providing original perspectives? Is it outlining original work? Are the methodologies suitably rigorous? Is the discussion of this idea or this project grounded in the literature, the published literature around this field? Um, Whereas the studio is far more of a, it's not simply show and tell, because we ask people to think about when they're describing the particular kind of case study that they're explaining to us, kind of what methods they used and why they used them, and what the impact has been. Um, but there are, there was one on the example on the screenshot I showed you called Couples Counsel, which is an app that's been developed for use in South America in relation to couples sorting out their legal affairs, which might include a will. There are other initiatives within the field of legal design that are doing similar things. One of my favorite projects, it's not in the journal, one of my favorite projects is a for-profit company in America called Hello Divorce. That
Love it.
the It was an experienced family attorney in California who realized that 80% of Americans didn't access any professional legal advice when they went through the process of divorce. And she also worked out that 80% of Americans are not below the poverty line. There are people who have money who will pay for professional services who, for some reason, are not going to attorneys. Why? Because it's opaque, because it's too expensive, because there's uncertainty around the charging fees, because the services themselves don't take advantage of technology. So she just put all those things together. She did kind of user experience research, she put together technology, design, and she's providing for-profit services in a far more accessible way. And I must send her an email to say, can you write for the next issue of the journal? So those are and there are other sorts of examples, some of which were included in the first issue of the journal, and hopefully we'll have lots more.
Thank you.
Can I butt into Gillian's question, which is that your will would have been drawn up by a local lawyer, and so Michael, isn't your challenge in legal design to sort of change the culture of lawyers who are in practice? So rather than have big projects done by big projects teams which do important documents, actually every local lawyer should stop writing in legalese and start writing in a kind of designed way, which is actually quite difficult. And it means
Yes.
sort of bringing information design techniques about highlighting things or making the structure visible, as well as plain language,
Mm.
that into the skills of every lawyer who writes a will.
Yeah. Yeah. it's a challenge to completely revolutionize the way in which law is practiced and which legal services are done right the way around the world. But it's interesting kind of the way you frame the question. I haven't kind of independently, I've addressed all those different things, but I'd never kind of put them together before. So, you know, one of the nice examples that I use of the, you know, the impact of legal design is that the head of digital legal affairs at HSBC went to the Legal Design Summit in 2019 in Helsinki, which was the first one that I went to. She was there for 2 days, and by the time she'd landed back in Hong Kong, she'd hired the 5 biggest legal design agencies in the world to say, I want us to completely rewrite all of our business-facing legal documents. And that's the, you know, the big splash. And Airbus, you know, is the big splash. But so I became a professor in 2019, but I changed my academic title last year to become professor of legal design. So it gave me an excuse to do an inaugural professorial lecture, and I had a really lovely night. All my family was there, but I had to explain legal design to this audience. And one of the things that I said to them was that certainly in the UK, if you go into a high street lawyer on a fairly sort of regular run-of-the-mill legal issue, like a conveyance, or getting probate on a will, or getting a will drafted, or a divorce, the first thing that will happen is you'll sit down with a lawyer and they'll take out a pen and they'll say, very nice to meet you, this is who I am, now what's your name? And they'll write it down on a piece of paper, and then address, and they'll write that down. And then you'll go through and go, okay, let's talk about the will, and what, you know, how much is your house worth, and da, 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 da. And then they'll go away afterwards.
Oh, we've lost your sound, Michael. Have you bumped your microphone off or something?
That's odd.
Try
again. Is better?
If I carry on talking.
Yeah, that's better.
Perfect.
Okay, yeah. So basically, I was saying like how inefficient and archaic most high street legal services are. And obviously there are some fairly straightforward tech solutions to that, you know, but I teach a little bit of legal design with my students now. So these are the lawyers of the future who are going to be out providing legal services. And there are other programs around the world. And I just give them a taste of legal design. But the big thing I try to impress on them is just that shift of perspective, to try to understand how you provide legal services from the perspective of the user. And we use kind of various tools to get them to think about that. And one of the things I want to do is I want to sell it to them as a valuable perspective, so that when they go out to firms, it's not like, hey, I've learned this legal design thing and it's really cool and it's really trendy and this and that. I want them to go, by applying these tools to how we do law in this firm, we can get a competitive advantage. We can take care of our clients better. We can reach new markets that have previously been thought not to be profitable for legal services. We can have more repeat business, etc., etc. So it's going to be a slow process, but you know, in the same ways as people have been saying for years, you know, legal tech won't replace lawyers, but lawyers who use legal tech will replace those who don't. Kind of, we want to get kind of a parallel message going on in relation to design or human-centeredness.
The one issue I've been observing. So Kim, you come in there because you your hand up. Hi there. Muted.
Yeah, thank you, Rob. Nice to see you again. Yeah. Thank you, Michael, and for your more or less introduction into the Legal Design Journal. And I did see it, the first start, like the launch on the Legal Design Summit last time. and I really like what happened and how it filled up. My question now has to do quite a lot with what's my background, which is really design and information design. And what I do feel kind of that it still is a lot of text and not that much visualization, which is kind of still the balance we, I think, are looking for in legal design. Where does the design comes in? And where does the legal comes in, and where do they really connect? Where do they have like the pluses of each other's expertise? Can you say something more about that as well?
Thank you. Yeah. Yes, I hope so. So the balance between sort of text and other sorts of visual elements, I think ideally depends very much on the audience. So some of the examples of projects that I gave you the briefest kind of flash of on the presentation can be quite visual heavy, because they're not in and of themselves legal documents. They're a guide to legal processes and legal experiences. And they're designed to for people who otherwise would have no access to legal information or advice. Now that's different from trying to introduce design elements in relation to a commercial contract. So for what the lawyers would say in relation to a commercial contract is, there is a reason why it's 120 pages long. We aren't just doing that for the fun of it. It's over the last 200 years of the development of contract law in a capitalist system in common law countries. Each of those clauses identifies a risk of something that might go wrong in the contractual relationship, and provides a proviso or a safeguard in relation to it. So if you ask me to take all that out and have a 5-page visual contract, you're asking me to act in a professionally negligent way. Yeah. Okay, fair. Okay. It doesn't mean that the entirety of the contract has to be presented in that way. It doesn't mean that you have to have 120 pages with essentially kind of one level of information tagging going on in relation.
Lost your sound.
Oh, yes, it is. We lost the sound again.
No.
No.
I'm sorry, Michael, we can't hear you.
No.
Yes, yeah. Working.
Actually,
working again. Yeah.
Again. Yeah. Okay. I will conclude briefly on that. Yeah, I think it's, I say, we're a very new field of practice. I think to some extent we're still working out the appropriate balance between text and other visualization objects. It very much depends on the sort of document. But even for the most kind of intensely technical legal documents, there are lots of examples over the last 10 years that have shown that you can introduce visual elements to them to make them even slightly more accessible and slightly more usable for a non-legal audience.
Yeah. Can I add to that? Maybe we may have met at the summit, but my background is visual journalism, and I'm working as a information designer at one of the law firms in the Netherlands. So I've been working inside a law firm for over 9 years now. And my interesting point of it is that, or view on it is that lawyers start with text, and you do think as a designer that they're kind of afraid of losing this text, but they are very, very accessible if you can explain why you are changing parts of the text. But also legal design for me is not only about contracts, it's a lot about giving the insights in or making things easier for just everybody. And as you said, in the teaching I do around legal design, I see that the students are more they have benefit about learning how to make personas more than how to draw the perfect icon in some way. But they have to learn to combine these things in the end. And that's something which is really not yet in the legal field, in the teaching legal field. So that makes me really interested in how this is going to evolve and what your role is going to be in this and what's the role of the legal design journal in it. So
I think that's quite a good place. Actually, we've come to the hour, and that's not a bad place to stop, because we've just raised some issues. We could go on talking for hours about these things, but Michael, thank you so much. That's really, really interesting. And I think I'm very inspired by what you've done and how you've made it open access and how you've combined practice and scholarship. I think that's fairly unique. I'm pleased to say in the more general information design field that Visible Language, one of our journals, has gone open access recently as well. So that's real progress. Unfortunately, Information Design Journal is behind a paywall, which is why no designers seem to read it because they can't afford it. But thank you.
Well, it's been a pleasure to speak with you all this afternoon. Thanks for the invitation again.
That's great. We must come back to legal design in another conversation. Too long. But thanks very much, everybody, for joining us.